questions that are submitted ahead of time. So I'm going to go ahead and answer those as I get some of this technology working. Really enjoy these, and we always start with a positive focus, something positive that happens the previous week. And for me, my positive focus is that my parents had taken my kids to Boston for the week. So they got to spend some kid and grandparent time, and my kids got to experience Boston. So that was pretty cool for them. So again, if you do have questions, feel free to put it in the chat or the question and answer section. I do have some emails submitted ahead of time, so I'm going to go ahead and address those. And if something's unclear, please put it in the Q&A or the chat section, and I will try to clarify. These aren't scripted. There's no PowerPoint or anything. It's really just answering your legal, financial, and tax questions. So with that, let me share my screen. Hit this button, hit that button, hit this button, and share, and do that. All right, we should be seeing my whiteboard in just a moment. So again, these are always just general information. If you want to see how this specifically applies to your situation, then make sure to reach out to us, email, or give us a call. So the first question here is, my dad passed away, leaving us 3 kids, the family cottage. And with that, what should we do to protect it? Do we need a trust or something? So the answer is it depends. So this is pretty common, especially in Michigan here, where we have that family cottage up north that is been in the family and is important. And so let's say we have dad, and dad finally passes away, and now let's say dad leaves it to 3 kids. So we'll say 3 kids, right? And it's this kind of family cottage that maybe it's on one of the lakes or something, but the goal is to try to keep it in the family. So if we had met with dad, then we do some things ahead of time in terms of dad's estate plan, but we didn't. So let's assume that we haven't met with dad, and now let's say the kids are inheriting the property. So what do we do with it? Well, what are the concerns? So the first concern, or what is the goal? So the goal is keep the cottage in the family, right? So how do we keep this in the family? And then also we want to understand, probably have a goal of how to manage it. So how to manage this kind of joint asset between, say, 3 people. Because what are the concerns? Well, the common concerns, what happens if like one of the kids gets divorced? Okay, now that cottage might be attacked. Or what if one of them needs long-term care in the future? Now, do they have to sell that cottage to pay for that? Or one of them gets creditor action, right? So we have these kind of common liability concerns. So one of the things that we can do is we can set up a trust, an asset protection trust, maybe that all 3 kids are trustees of. And now we assign it or move that property into the trust. So all 3 kids would basically sign off on this trust and be co-trustees to deed their interest into the trust. Now, if any of these bad things happened individually to them, it would be held in the trust. Or what happens if, let's say, not a divorce, but what if one of the kids were to pass away? Well, the goal is for it to stay in the family, stay in the bloodline, versus going to a spouse, where now a spouse who might then remarry in the future, and now that family cottage is outside of the scope of the bloodline, the family. That's where, again, a trust can dictate that, no, if one of the siblings passes away, it doesn't go to a spouse, but instead it would stay in the bloodline, and maybe if there were 2 kids, now their share would go to the 2 children. So it'd flow down to the grandkids. So that's accomplished through maybe an asset protection trust. Okay. So that's how we can protect against creditors, divorce, death, long-term care, to really to keep it in the family. So that's one level of planning. Now, the other issue is, how do we manage that, right? So again, as attorneys and advisors, we're always trying to look at worst case scenario and what are the risks and that type of thing. So those are outside risks. What about what I'll call kind of internal risks? So we have the 3 kids, and let's say the goal is for all of them to kind of throw in money to manage this, right? But what if one of the kids, or what if there's a issue with the property, and let's say it needs a new roof or something like that, and then each kid would then have to throw in money to pay for that new roof, or if there's an association or a club membership or just the taxes, what happens if one of the kids doesn't throw in? Or what happens if they want to make improvements? How do you manage that? Well, that's where a trust really isn't going to be sufficient. Instead, what we also might want to do is a LLC, a limited liability company, because in reality, these 3 siblings are now managing, in essence, a business, right? They need a set of rules, and with that LLC, we would probably want to have an operating agreement of, okay, here's how we're going to manage things. Is it going to be by majority? What happens if one of the kids can't throw in to cover taxes? Is there any penalties, or do they get kicked out of the LLC, or of the of having any say in the property? Or how do you handle what happens if one family wants to take the cottage for a weekend, and another family wants that same weekend? How do you work that out? So those are all things that could be handled through an operating agreement. So depending on what your goals are, we might have a trust, we might have an LLC, an operating agreement, and then of course we'd have a deed deeding the property to the trust. And then if we do have a LLC, an operating agreement, also we'd want to have assign the LLC to the trust. So sometimes something like really simple, like just how do we pass the family cottage, or if we were to inherit a family cottage, seems simple, but it's a little bit more complicated when you think about all the things that could go wrong, especially as you start adding multiple beneficiaries. Now, ideally, we would have worked with Dad before he passed away, so all of this could have been structured ahead of time, and he could lay out the rules of how everything is handled. But now, if 3 kids are inheriting it, all 3 kids have to agree on how, kind of, what are the rules. So it's an interesting question, and it's a little deeper than it seems like on its face. So if you do have a family cottage and you want that family property or second piece of property to stay in the family, it doesn't have to be something up north. Just if you know that there's a piece of property that's going to be split amongst multiple people, some things to consider. First of all, creditors, divorce, death, long-term care costs, and then just kind of the internal family issues that could arise as well. And so these are some of the tools we use to address that. All right, that's the first question. The legal questions this week, it looks like. See if any questions or answers. Nope. All right. Then getting into my next question submitted. Again, if you do have questions or anything you want me to cover, or something's unclear, feel free to put it into the chat. So the next one, please clarify the use and of executor, agent, personal representative, trustee. So a person's doing some research online, sees them defined kind of differently or used interchangeably. Well, 2 of these basically go together, an executor and personal representative. And a lot of these are just talking about what is the role underneath a specific tool. So in a will, you appoint someone to wrap up your final affairs. And depending on which state you're in, that's either going to be a personal representative, which is what we call it in Michigan, or an executor. It really, this is the same term, same role, same responsibilities. It just depends on what state you're in, whether they call it a personal representative or an executor. In Michigan, we call it a personal representative. As I say that, I'm kind of like blanking on it and I'm second guessing myself. I witnessed 3 wills today, but I'm 99% sure we call it a personal representative. Need my afternoon coffee to kick in. But it's, in the end, it's the same role. It's the person who wraps up the affairs. If there's anything going through probate, they would manage probate. Then we have the role of a trustee. And really, it's basically the same role as that of a personal representative or executor, but the power is coming from a different document. It's coming from a trust. So ideally, keep in mind that a will only really gives instructions to the probate court. So if you're looking at avoiding probate, you don't want to rely on a will, because only probate court really looks to the will. So if you're looking at avoiding probate, if you want to avoid probate, then typically you're going to look at a trust. So with a trust, we don't have a personal representative or executor, we have what's called a trustee. Now, in essence, it is the same thing, or it's equal to the same, basically the same role or responsibilities. It's just under a different document. The power, I can't spell and type and talk at the same time. It's basically the same thing. It's just, where is that person getting the power? And then that gives them then they're going to be called something depending on whether they're acting under the will or the trust. Same role, same responsibility. You wrap up final affairs, you distribute the assets where they're supposed to go. So that's the executor, that's personal representative, and then trustee. Now, the term agent typically is going to be either under a financial power of attorney, or you're going to have a medical power of attorney. And these are really dealing with incapacity. So a trust and a will typically is dealing upon death. Financial power of attorney, medical power of attorney is typically dealing with incapacity. So you might, in the financial power of attorney, you might hear it called a general durable power of attorney or durable power of attorney. The medical power of attorney, you might hear it called a patient advocate designation, which is a technical term in Michigan. You might hear it called a healthcare power of attorney, advanced directives. Really, all of those are basically the same thing. And when we're talking about comprehensive estate planning, typically we're talking about having a trust to avoid probate, control the distribution, maybe building an asset protection, a will, financial power of attorney. So if you get a knock on your head, who's going to make financial decisions? Medical power of attorney. And then if you own real estate, a deed, deeding the property typically to the trust. And then you might also have what's called a personal care plan that gives instructions with regards to long-term care. So really, each one of these is a tool. And with the trust, we have the role of the trustee. With the will, we have the role of the personal representative. With the financial power of attorney, we have the agent appointed as financial power of attorney. With the medical power of attorney, we have the agent that's been appointed to make medical decisions for you. And then the deed is just funding your real estate. That doesn't really have any specific roles, nor does the personal care plan. So hopefully that was a little bit of education just on the terms or the technical terms we use. And as you're doing your online research, that should be helpful. Now, last question that I have submitted. So if you do want anything else covered on our webinar today, please put it into the Q&A. Otherwise, I'll answer this third and last question we have. So what is the function of a trust protector? What fee does a trust protector charge? And is the trust protector the same thing as administrator? I guess administrator could be another term for trustee. So this could be another kind of term for a trustee or even personal representative executor. It's more of a general term, the person who administers the trust. Technically, we call it a trustee. But yeah, so the role of a trust protector, it's really defined by the document. But typically the reason why we would build in trust protectors, we don't always have to, and it's not required, but it just gives us more flexibility. So if a trust were to lock down for whatever reason due to incapacity or death, and there's some type of change that should be made, you can have a trust protector appointed, which could be the person drafting the documents, could be someone else, but typically it's the person who drafts the documents is named as a trust protector because they're most familiar with what's going on. But we hardly have ever had to use the role of a trust protector. But what it is it just gives some flexibility to documents that become irrevocable at some point. So while you're alive and well, typically you can make changes, but a lot of times there will become a point, or maybe you'll set up an irrevocable trust where some terms of the trust or provisions are locked down to a certain extent. So by appointing a trust protector, rather than having to go to court, we can make whatever changes may be necessary. Probably the best example where we've utilized the role of the trust protector. This was a number of years ago. I had a client, special needs client. We set up a special needs trust a number of years ago. Mom and dad passed away. We had named, let's say, Bank of America as the trustee of the special needs trust. And then Bank of America decided to stop servicing special needs trusts at this level of assets. And so rather than having to go to court to appoint, say, another trustee, we were able to use the trust protector language to administratively make a change to a document that had become irrevocable upon death. To appoint another trustee. So we're able to affect the goals of the planning without having to spend the time, effort, and money of going to court to get those changes made. So think of it as just one ability to build in kind of one last chance, one last bite of an apple before we would have to go to court to make some changes to documents. So it just gives some flexibility. It's not required or necessary in every document, but in certain circumstances, it typically makes sense. So that's the role of a trust protector. Now we've covered a lot of the roles of a trust or estate plan: executor, agents, trustees, trust protectors. So hopefully that was helpful. And that's really all the questions that were submitted or that I've seen come across. So let me know if there's any other last questions or anything you want me to cover this week, and I will go ahead and answer that. So if you have anything else, you can feel free to put it into the chat. Vicky says, enjoy your day. Thank you. It looks like a sunny one out there. I wish I could go out and play on the lake, but I'm not today. Any other questions? Going once, going twice. Good to see you, Chris. Thank you, Nikhil. All right, we'll call it a day. All right, thank you so much. If you do have questions, feel free to shoot over an email. Otherwise, make it a great day. Keep enjoying the wonderful weather that we've been having. And I will maybe see you next week if you'll be online with me. Thank you so much.